States and Minorities Appendices by Babasaheb Ambedkar. Appendix 1. Explanatory Notes. Article 2, Section 2, Clause 1. Rights are real only if they are accompanied by remedies. It is no use giving rights if the aggrieved person has no legal remedy to which he can resort when his rights are invaded. Consequently, when the Constitution guarantees rights, it also becomes necessary to make provision to prevent the legislature and the executive from overriding them. This function has been usually assigned to the judiciary, and the courts have been made the special guardians of the rights guaranteed by the Constitution. The clause does no more than this. The clause proposes to give protection to the citizen against executive tyranny by investing the judiciary with certain powers of inquisition against the abuse of authority by the executive. This power takes the form of issue of writs. The high courts in India possess these powers under the government of India and under their letters patent. These powers are, however, subject to two limitations. In the first place, the powers given by the letters patent are available only to the high courts in the presidency towns and not to all. Secondly, these powers are subject to laws made by the Indian legislature. Thirdly, the powers given by the Government of India Act 1935 are restricted and may prove insufficient for the protection of the aggrieved person. The clause achieves two objectives. One, to give the fullest power to the judiciary to issue what under the English law called prerogative writs, and two, to prevent the legislature from curtailing these powers in any manner whatsoever. Clause 2. It is difficult to expect that in a country like India, where most persons are communally minded, those in authority will give equal treatment to those who do not belong to their community. Unequal treatment has been unescapable in the untouchables of India. The following extract from the Proceedings of the Board of Revenue and the Government of Madras, number 723, dated 5th November 1892, illustrates the sort of unequal treatment which is meted out to the scheduled castes by Hindu officers. Says the report 134. There are forms of oppression only hitherto hinted at which must be at least cursorily mentioned. To punish disobedience of P word, their masters A. Bring false cases in the village court or in the criminal courts. B. Obtain on application from government wastelands lying all round the Paracherry so as to impound the P. cattle or obstruct the way to their temple. C. Have Mirasi names fraudulently entered in the government account against the Paracherry. D. Pull down the huts and destroy the growth in the backyards. E. Deny occupancy rights in immemorial subtenancies. F. Forcibly cut the P-word crops and on being resisted charge them with theft and rioting. G. Under misrepresentations get them to execute documents by which they are afterwards ruined. H. Cut off the flow of water from their fields. And I. Without legal notice have the property of subtenants attached for the landlord's areas of revenue. 135. It will be said that there are civil and criminal courts for the redress of any of these injuries. There are the courts indeed, but India does not breed village Hamptons. One must have courage to go to the courts, money to employ legal knowledge and meet legal expenses, and means to live during the case and the appeals. Further, most cases depend upon the decision of the first court, and these courts are presided over by officials who are sometimes corrupt and who generally, for other reasons, sympathize with the wealthy and landed classes to which they belong. 136. The influence of these classes with the official world can hardly be exaggerated. It is extreme with natives and great even with Europeans. Every office, from the highest to the lowest, is stocked with their representatives, and there is no proposal affecting their interests, but they can bring a score of influence to bear upon it in its course from inception to execution. The Punjab Land Alienation Act is another illustration of unequal treatment of the untouchables by the legislature. Many other minority communities may be suffering from several treatment at the hands of the majority community. It is therefore necessary to have such a provision to ensure that all citizens shall have equal benefit of laws, rules, and regulations. The provisions of Clause 2 are borrowed from Civil Rights Protection Act 1866 and of March 1st, 1875, passed by the Congress of the United States of America to protect the black people against unequal treatment. Clause 3. Discrimination is another menace which must be guarded against if the fundamental rights are to be real rights. In a country like India, where it is possible for discrimination to be practiced on a vast scale and in any relentless manner, fundamental rights can have no meaning. The remedy follows the lines adopted in the bill which was recently introduced into the Congress of the USA, the aim of which is to prevent discrimination being practiced against the blacks. Clause 4. The main purpose behind the clause is to put an obligation on the state to plan the economic life of the people on lines which would lead to the highest point of productivity without closing every avenue to private enterprise and also provide for the equitable distribution of wealth. The plan set out in the clause proposes state ownership in agriculture with a collectivized method of cultivation and a modified form of state socialism in the field of industry. It places squarely on the shoulders of the state the obligation to supply capital necessary for agriculture as well as for industry. Without the supply of capital by the state, neither land nor industry can be made to yield better results. It also proposes to nationalize insurance with a double objective. Nationalized insurance gives the individual greater security than a private insurance firm does, inasmuch as it pledges the resources of the state as a security for the ultimate payment of his insurance money. It also gives the state the resources necessary for financing its own economic planning, in the absence of which it would have to resort to borrowing from the money market at a high rate of interest. State socialism is essential for the rapid industrialization of India. Private enterprise cannot do it, and if it did, it would produce these inequalities of wealth which private capitalism has produced in Europe and which should be a warning to Indians. Consolidation of holdings and tenancy legislation are worse than useless. They cannot bring about prosperity in agriculture. Neither consolidation nor tenancy legislation can be of any help to the 60 millions of untouchables who are just landless laborers. Neither consolidation nor tenancy legislation can solve their problem. Only collective farms on the line set out in the proposal can help them. There is no expropriation of the interests concerned. Consequently, there is sought to be no objective to the proposal and objection to it on that account. The plan has two special features. One is that it proposes state socialism in important fields of economic life. The second special feature of the plan is that it does not leave the establishment of state socialism to the will of the legislature. It establishes state socialism by the law of the Constitution and thus makes it unalterable by any act of the legislature and the executive. Students of constitutional law will at once raise a protest. They are sure to ask, does not the proposal go beyond the scope of the usual type of fundamental rights? My answer is that it does not. If it appears to go beyond, it is only because the conception of fundamental rights on which such criticism is based is a narrow conception. One may go further and say that even from the narrow conception of the scope of constitutional law as comprising no more than fundamental rights, the proposal can find ample justification. For what is the purpose of prescribing by law the shape and form of the economic structure of society? The purpose is to protect the liberty of the individual from invasion by other individuals, which is the object of enacting fundamental rights. The connection between individual liberty and the shape and form of the economic structure of society may not be apparent to everyone. Nonetheless, the connection between the two is real. It will be apparent if the following considerations are borne in mind. Political democracy rests on four premises which may be set out in the following terms. 1. The individual is an end in himself. 2. That the individual has certain inalienable rights which must be guaranteed to him by the Constitution. 3. That the individual shall not be required to relinquish any of his constitutional rights as a condition precedent to the receipt of a privilege. 4. That the state shall not delegate powers to private persons to govern others. Anyone who studies the working of the system of social economy based on private enterprise in pursuit of personal gain will realize how it undermines, if it does not actually violate, the last two premises on which democracy rests. How many have to relinquish their constitutional rights in order to gain their living? How many have to subject themselves to be governed by private employers? Ask those who are unemployed whether what are called fundamental rights are of any value to them. If a person who is unemployed is offered a choice between a job of some sort, with some sort of wages, with no fixed hours of labor, and with an interdict on joining a union and the exercise of his right to the freedom of speech, association, religion, etc., can there be any doubt as to what his choice will be? How can it be otherwise? The fear of starvation, the fear of losing a house, the fear of losing savings, if any, the fear of being compelled to take children away from school, the fear of having to be a burden on public charity, the fear of having to be burned or buried at public cost are factors too strong to permit a man to stand out for his fundamental rights. The unemployed are thus compelled to relinquish their fundamental rights for the sake of securing the privilege to work and to subsist. What about those who are employed? Constitutional lawyers assume that the enactment of fundamental rights is enough to safeguard their liberty and that nothing more is called for. They argue that what and where the state refrains from intervention in private affairs, economic and social, the residue is liberty. What is necessary is to make the residue as large as possible and state intervention as small as possible. It is true that where the state refrains from intervention, what remains is liberty. But this does not dispel of the matter. One more question remains to be answered. To whom and for whom is this liberty? Obviously, this liberty is liberty to the landlords to increase rents, for capitalists to increase hours of work and reduce rates of wages. This must be so. It cannot be otherwise. For in an economic system employing armies of workers producing goods en masse at regular intervals, one must make rules so that workers will work and the wheels of industry run on. If the state does not do it, the private employer will. Life otherwise will become impossible. In other words, what is called liberty from the control of the state is another name for the dictatorship of the private employer. How to prevent such a thing from happening? How to protect the unemployed as well as the employed from being cheated out of their fundamental rights to life, liberty, and the pursuit of happiness? The useful remedy adopted by democratic countries is to limit the power of government, to impose arbitrary restraints in political domain, and to invoke the ordinary power of the legislature to restrain the more powerful individuals from imposing arbitrary restraints on the less powerful in the economic field. The inadequacy may be with the fertility of the plan has been well established. The successful invocation by the less powerful of the authority of the legislature is a doubtful proposition, having regard to the fact that even under adult suffrage, all legislatures and governments are controlled by the most powerful. An appeal to the legislature to intervene is a very precarious safeguard against the invasion of the liberty of the less powerful. The plan follows quite a different method. It seeks to limit not only the power of government to impose arbitrary restraints, but also of the more powerful individuals, or to be more precise, to eliminate the possibility of the more powerful having the power to impose arbitrary restraints on the less powerful by withdrawing from the control he has over the economic life of people. There cannot be slightest doubt that of the two remedies against the invasion by the most powerful of the rights and liberties of the less powerful, the one contained in the proposal is undoubtedly the most effective. Considered in the light of these observations, the proposal is essentially a proposal for safeguarding the liberty of the individual. No constitutional lawyer can therefore object to it on the ground that it does go beyond the usual scope of constitutional law. So far as the plan has been considered purely as a means of safeguarding individual liberty. But there is also another aspect of the plan which is worthy of note. It is an attempt to establish state socialism without abrogating parliamentary democracy and without leaving its establishment to the will of a parliamentary democracy. Critics of state socialism, even its friends, are bound to ask why make it a part of the constitutional law of the land? Why not leave it to the legislature to bring it into being by the ordinary process of law? The reason why it cannot be left to the ordinary law is not difficult to understand. One essential consideration for the success of a planned economy is that it must not be liable to suspension or abandonment. It must be permanent. The question is how this permanence can be secured. Obviously, it cannot be secured under the form of government called parliamentary democracy. Under the system of parliamentary democracy, the policy of the legislature and of the executive is the policy of the majority for the time being. Under the system of parliamentary democracy, the majority in one election may be in favor of state socialism in industry and in agriculture. At the next election, the majority may be against it. The anti state socialism majority will use its lawmaking power to undo the work of the pro state socialism majority, and the pro state socialism majority will use its lawmaking powers to do over again what has been undone by their opponents. Those who want the economic structure of society to be modeled on state socialism must realize that they cannot leave the fulfillment of so fundamental a purpose to the exigencies of ordinary law, which simple majorities, whose political fortunes are never determined by rational causes, have a right to make and unmake. For these reasons, political democracy seems to be unsuited for the purpose. What is the alternative? The alternative is dictatorship. There is no doubt that dictatorship can give the permanence which state socialism requires as an essential condition for its fruification. This is, however, one fact against dictatorship which must be faced. Those who believe in individual freedom strongly object to dictatorship and insist upon parliamentary democracy as a proper form of government for a free society. For they feel that freedom of the individual is possible only under parliamentary democracy and not under dictatorship. Consequently, those who want freedom are not prepared to give up parliamentary democracy as a form of government. However much they may be anxious to have state socialism, they will not be ready to exchange parliamentary democracy for dictatorship, even though the gain by such an exchange is the achievement of state socialism. The problem, therefore, is to have state socialism without dictatorship, to have state socialism with parliamentary democracy. The way out seems to be to retain parliamentary democracy and to prescribe state socialism by the law of the Constitution so that it will be beyond the reach of parliamentary majority to suspend, amend, or abrogate it. It is only by this that one can achieve the triple object, namely to establish socialism, retain parliamentary democracy, and avoid dictatorship. The proposal marks a departure from the existing constitutions whose aim is merely to prescribe the form of the political structure of society, leaving the economic structure untouched. The result is that the political structure is completely set at naught by the forces which emerge from the economic structure, which is at variance with the political structure. Those who want socialism with parliamentary democracy and without dictatorship should welcome the proposal. The soul of democracy is the doctrine of one man, one value. Unfortunately, democracy has attempted to give effect to this doctrine only so far as the political structure is concerned by adopting the rule of one man, one vote, which is supposed to translate into the fact the doctrine of one man, one value. It has left the economic structure to take shape to those who give it by those who are in position to mold it. This has happened because constitutional lawyers have been dominated by the antiquated conception that all that is necessary for a perfect constitution for democracy was to frame a constitutional law which would make government responsible to the people and prevent tyranny of the people by the government. Consequently, almost all laws or constitution which relate to countries which are called democratic stop with adult suffrage and fundamental rights. They have never advanced to the conception that the constitutional law of democracy must go beyond adult suffrage and fundamental rights. In other words, old time constitutional lawyers believed that the scope and function of constitutional law was to prescribe the shape and form of the political structure of society. They never realized that it was equally essential to prescribe the shape and form of the economic structure of society if democracy is to live up to its principle of one man, one value. Time has come to take a bold step and define both the economic structure as well as the political structure of society by the law of the Constitution. All countries like India, which are latecomers in the field of constitution making, should not copy the faults of other countries. They should profit by the experience of their predecessors. The end.